Our guests today are Lily Brown, partner of WilmerHale here in Washington, D.C. Lily spent 14 years working at the SEC, senior special counsel to Corp Fin Director Meredith Cross, and David Kanarek, who's vice president and group counsel in the general counsel's organization of American Express Company up in New York. I'm Brock Romanak. We're going to talk risk factors today on Zippy Point. Lily and David, there's hardly been any changes, if any, about risk factors, the regulations requiring them in my career, but now we do have some changes. So Lily, under these new regulations, size all of a sudden does matter, it seems like, or does size matter? What is the business about page counting and summaries and all of that?
Right. So the SEC has for many years been attempting to kind of get folks to streamline, not use generic risk factors. And the newest effort, it had traditionally been more through comment letters, but the newest effort is through rulemaking. So with the recent rulemaking, which impacted, among others, Item 105 of SK, issuers are now going to be required to provide a summary of their risk factors of no more than 2 pages if they exceed 15 pages in risk factors overall. So that's going to be an issue for a number of folks, as you can imagine. Some have tighter risk factor sections, but many, particularly in certain industries, are going to have well over 15. So now size really does matter, because if you exceed that 15 pages, you're going to have to come up with a tight little summary at the front of the risk factors. Now, the guidance that is provided in 105 is that the summary can be a series of concise, bulleted, or numbered statements. The adopting release does make clear that you don't have to include all of the risk factors in the summary. A terrible summary, I think, if you did. So you're going to be kind of flagging the most material up front. And there isn't kind of authoritative guidance at this point as to exactly what one will want to do in this regard. But one of the thoughts that's kind of, I think, been attributed back to Corp Fin is that one might use kind of a forward-looking statement section type approach. But it remains to be seen kind of how people are going to approach this.
And how about the change from a threshold of most significant to material? How might that change practice? Or, how hard will it be to delete risk factors that you've used forever under this change?
Well, so also as part of the amendments, the standard was moved from most significant to material. And this was intended, as stated by the SEC, to focus companies on disclosing the risks that a reasonable investor would attach importance to, right, in making an investment or a voting decision. Again, it's part of the overall effort to tailor this section of an issuer's disclosures. I don't know how much change this piece on its own will result in. I mean, I think many read materiality into the old standard anyway. I think we're also kind of comfortable with the materiality standard. Maybe it will impact, and I think the goal is to impact some of those catch-all, more general risks. But as I mentioned, those have survived years of attempts. They're kind of like the cockroaches. You can't get them. The SEC. I harken back to the years when we would issue comment upon comment on general risk factors, but they have survived. So we'll see if I don't know that this on its own will be enough to kind of change practice in that regard. When you look holistically at the rule changes, though, it is possible that we will see a tightening up when you combine the movement to materiality for most significant with the page limit and with the new section where you'll have to kind of relegate the general risks off to their own little section with a subheading. So we'll see. I do think it's really hard, though, to strip out risk factors that have been in your filings, because it's kind of like that article of clothing that you don't use anymore. You think, well, maybe someday I will need that. But I do think this will, at a minimum, result in people taking a much closer look at their risk factors to see how to tidy up. And that 15-page limit, I think, will be a strong incentive to do that.
Yeah, the lawyer in me finds this really interesting because, of course, like you said, the materiality threshold is one that's been fleshed out by case law that we've discussed a lot. Some of the SEC rules and regs, and particularly on the accounting side, discuss materiality, but most significant is not one of those terms that is actually bandied about much in the securities law arena. And so even though the little bit of lawyer in me dies every year as I get older, every wig I put on in the video, there's still a little bit of lawyer in me left. So David, putting on your in-house hat, since you're in-house, how might companies change their headings under these new regs?
Yeah, the concept here is to improve readability and usefulness of the section generally. And what we should be looking to do is organize risk factors under the relevant headings. So think about what are your business and strategic risks, regulatory legal risks, market risks, risks related to a securities offering or your ownership structure or governance. And then the SEC would have you put a general risk section at the end. I think that people are going to want to try to avoid that general risk heading. It's really those generic risks that are going to apply to any company or an offering of securities. But I think that even risks that companies might think would be generic, like changes in accounting standards, reliance on key personnel, or natural disasters, those are things that are going to be very easy to tailor in your risk factors, and that natural disasters risk factor can very easily go into a business or a strategic issue, thinking about where you might have exposure to maybe in floodplain areas or wildfire areas. Those are where you just put in we are subject to things we can't control. For example, natural disasters, and this is why. And I think that will help companies put them into relevant headings and avoid that general risk factor heading.
So updating risk factors, this is what every company is going to have to do with the change in the SEC's rules and regs, because if you're an existing public company, you have some risk factors out there. So I think it's obvious, given the liability protection purposes of risk factors, that inevitably the risk factor disclosure should speak as of the date that you file your 10Q, your 10K, not the end of the reporting period. Is that right, Lily?
That's right. That's the short answer. Yes. The longer answer is, the risk factors are going to be fluid and living up until you file your K or your quarterly report. You don't want to be in a position of filing a document that you know that doesn't capture the material risks for the company and its investors. And as you're thinking about kind of trending risks and whether they're sufficiently material for disclosure, you want to be kind of looking down the road and thinking about the kind of the 2020 hindsight bias that may apply when disclosures are reviewed by the market or the SEC in the future. And so kind of thinking, okay, does this, has something that's happened during our drafting period impact what our disclosure should be? So it's not bound, the risk factor kind of item requirement, it's not bound by the reporting period covered by the report. And beyond that, it's to your benefit, right, to capture the risks in the most complete way possible, because it's protecting the company, right? It's an SEC disclosure requirement, but it's also protecting the company. So you want to have the most complete and current risk factor disclosure that you can from an anti-fraud and liability standpoint. So you have an incentive to be putting the cautionary language in there for folks to be able to assess the risk of investment or continuing to hold, or thinking about in terms of voting decisions. So back to the yes, there's not the requirement goes up until you file, and you also, just as a practical standpoint, want to be including the most comprehensive and current risks when you file.
And there's historically been two schools of thought. That one, companies have their laundry list of all of their risk factors in each 10Q, and then even if there's updates, they're just going to be in part of the laundry list of 10Q of the risk factors that you have in that 10Q. And then the second group are those companies that just provide the updated risk factors in a 10Q. They don't include the entire laundry list. David, what's your thinking on all of this?
Yeah, let's start with the rule itself. So in Form 10Q, you're supposed to set forth any material change from risk factors that are previously disclosed in the 10K. So narrowly read, you would think you were just to put forth your material changes. And you're right, practice is mixed here, though. I think a lot of companies do repeat their full risk factor set in each Q and continually, even maybe where there's no material update, because you can still make wording changes, immaterial changes. And while that causes you to go through that process, you could think about it as good hygiene. Every 3 months, you're looking back and revisiting the disclosure and making sure it's most up to date. As Lily was mentioning, bringing it down, even if there's not something that's materially changed. On the other hand, there is a process that you have to go through in order to do that. And if you really have nothing material to say that's different, you can also just rely on your existing risk factor package from the 10K. We've seen this quite a bit, obviously during this current year, where things are so fast moving in 2020. And I think you're seeing a lot more of these material changes as companies have been following their 10K.
And Lily, what's been your experience with the drafting process when companies are considering updating or crafting new risk factors?
So as with any disclosure, the process is going to be different at different companies. It depends on the size of your team, how much you rely on outside counsel, complexity of your organization and business, but there are certainly some constants. So the first is you need to sit down and say, okay, what may have happened over this quarterly period that may render my existing risk factors, right, the ones that are already out there, no longer complete. You may need a whole new risk factor, or you may need to revise an existing risk factor. So in some cases, that's going to be obvious, right? For example, a new pandemic. It's going to be something that it's top of mind for everyone. And we certainly saw that in the spring. In other cases, in most cases, it's going to be a more systematic process and more specific to your organization, right? And I'll just say it up front so that it's top of mind before I kind of talk more about process. Strong disclosure controls and procedures are important, right? You always want to have those top of mind with any of your disclosures, and that's equally the case for risk factors. You're going to end up needing a lot of coordination and consultation across the enterprise, depending again on how you organize it, buy-in among the disclosure committee, the drafting teams in legal and financial reporting, business folks, executive team. Best case scenario, you're able to do some pretty significant brainstorming on whether there are new risks that need to be reflected in the document, or if there are some that need to be changed or deleted. And you do want to be talking to, the senior management team leaders, the members, the leads of the different, business functions, operating units, divisions, to kind of find out what's happening in each of those groups that may result in new risk factor or changed risk factor disclosure. So kind of finding out what the leads throughout your organization are worrying about. Kind of the buckets that you look at in thinking about this are going to be, events that the company has experienced over the last quarter, right? So using cybersecurity, because that's always kind of the go-to and the easy one for risk factor disclosure. Have you experienced breaches or attempted breaches? Were they material? I'll say on that one, and we'll talk about it with something like cybersecurity. Odds are everyone has experienced an attempted breach. So the question will be, were they material? Does your disclosure already say that you have? And we'll talk about hypothetical risk factors and how not to have those. But basically just looking at what's happened to us over the last quarter, does it reflect a material risk that is not already captured in our disclosures? Are there events, that have happened to an industry peer, other companies, supplier, business partner? Is there something there that could be relevant to your company that, again, is not already captured in the risk factors? And then there are the external factors. We talked about the macro risks. You may have evolution of law, regulation, practice. So you want to be looking out into the market, looking at statements by regulators, looking at change in law. We saw a little while back the chairman of the SEC and also the Corp Fin director really specifically saying, hey, we're looking for disclosures in the area of the LIBOR changes or cybersecurity or Brexit. So you want to be attuned to what's happening outside the company as well, and making sure that you're kind of reflecting those. And, market practice, I mean, we're not all lemmings. We don't all want to do what everyone else is doing, but we kind of do, right? We don't want to we want to be specific to our companies, and our business, but at the same time, we don't want to be off market too. So it's good to at least know what's happening out with the marketplace, and to the extent that there is something that's material for your company, making sure that you're reflecting it, because you don't want to kind of be caught out as someone who was not with the market in terms of your disclosure. So then you're going to go back and you're going to look and say, okay, have I captured all of this? And ultimately, some combination of your legal and financial reporting team will be actually doing the drafting, often in consultation with outside counsel, often not. And then you'll run through the review process with your internal experts and leadership, kind of following the process in your particular company. Again, really cognizant of the importance of your disclosure controls and procedures. And thinking about, if there's something special, I talked about internal specialists. It could be your litigation team if it's a litigation related risk. So you just really have to think about the nature of the risk and who within your organization are going to be best equipped to review and help you to.
Yeah, there might be many layers of review. It really depends on the situation and also
Absolutely.
the time that you have to do that. So David, how does this work that if you have a new or an updated risk factor like in the first quarter, so that's in your first quarter 10Q, in your second and third quarter 10Qs, if you don't have any new developments about that topic, do you still need to include that particular updated or new risk factor in those second and third quarter 10Qs?
Yeah, I think the better read of that Form 10Q requirement that you don't have to include any updates unless there's material updates from your 10K would necessitate either stating that same risk factor that had come up, or there was a material change in the first quarter in your second and third quarter 10Qs, or you can accomplish that though with a hyperlink cross-reference back to your first quarter 10Q.
And then Lily, if you have a quarter where you have nothing new, no new updates for an existing risk factor or no new risk factor, do you have to have what I call negative disclosure? Some people call it affirmative disclosure, but basically disclosure saying there's nothing to report here.
You do not have to, but many folks do. I think practice is pretty mixed in this space. Most of the time, risks aren't going to change significantly quarter to quarter. And, if you're not one of those companies that restates the risk factors in each Q, you likely are going to be encountering this more quarters than not. Probably, hopefully. And so, this is one where there is kind of standard language that you'll often see here that says, no material changes from the risks stated in our 10K. But at the end of the day, it's not a requirement. And so practice is mixed.
How about using a 10Q to actually eliminate the killer risk factor? So it would basically say the development is that we no longer consider this a risk.
You can do that. I mean, it's part of kind of the overall evaluation that you do on a quarterly basis as to whether or not your risk factors capture the current risks that the company is exposed to. But it's not particularly common. It's kind of one of those things that you maybe are going to see a lot more frequently, or you are going to see more frequently in kind of the big housekeeping review that happens at the K. Yes, you are required to look at your risk factors quarterly, but this is one where it can look a little awkward. It can be hard to do in that way. And oftentimes, it's a little bit subjective as to when that risk is really going to fall off. So it may not feel like something affirmative enough has happened to cause it to fall off such that you would say, we're taking this out. And, it may be clear just from, within the marketplace already that a risk isn't there. And at the end of the day, also, this goes back to, kind of the concept of pulling risks out that maybe you've had for a long time. They're general. It's hard to get rid of risks. And it feels like a higher risk. Whereas we may say, okay, well, we need to add a new risk this quarter. It feels like a lower risk proposition to just continue on with a risk factor that maybe isn't so important anymore. So maybe you'll just tidy that up at the end of the year. So yes, you can do it. Most people do not.
And what about a risk that's very material that actually pops up in the middle of a quarter? Have you seen companies, or would you recommend that companies use an 8K to actually add or change a risk factor as it changes, or would you file an amendment maybe to the last 10Q or 10K to accomplish that?
So you are going to see instances where there is an off-cycle need to update risk factors. Big events don't always happen on your perfect quarterly schedule. So you will at times find out of cycle needs to kind of update the risk factors to maintain the accuracy and completeness of information. You see this in, when companies are in the market raising capital in particular. You really want to make sure that you have the risks incorporated into the registration statement. We saw a lot of this in the spring with COVID. That was a big new risk, right? That happened at a time when many folks were out there with registration statements. So you do see that happening in an 8K, an 801 8K, so that it gets incorporated by reference into the 33 Act filing versus a 701 that you would do just because you want it out there for FD purposes. But if you actually want to get it into the filings, you do that on an 801. So we do see that occasionally. You do not amend the prior K or Q to do it. You do it via an 8K, and then when it comes time for your next Q, you can reflect it there, and then you figure out with the K whether you want whether it's going to go into the risk factors or.
So now, rapid fire succession. We're going to get into the do's and don'ts of risk factors. This is going to be exciting. And Lily's going to kick us off with some captions.
1, use captions that tell the story, the essence. You want to convey the essence of the risk to the reader. And this is actually required under 105 that you have a subcaption that adequately describes the risk. And you will get comments, or you may get comments if your caption does not tell the story.
Use plain English. Make the risks understandable to a reader, and use examples. So this doesn't mean to be brief necessarily. The examples can expound a risk and make it more understandable for a reader.
3, order your risks in terms of risk magnitude. The SEC does not require companies to prioritize the order of their risk factors. However, companies typically do want to order their risks in terms of magnitude. And this makes sense in light of the purpose of risk factors. Magnitude, just as a reminder, does not necessarily equal materiality. If you have remote probability of something happening, it may not appear high up in your priority list, even if it would be very, very significant if it did happen.
4, categorize by common themes. Now, this is basically a requirement with the new rule to include risk factor headings. But it also means that you should try to categorize your risks even within the headings. So if you have commonalities between risks, keep them grouped. And even if that does mean that you don't necessarily have everything ordered in risk magnitude, as Lily just said, at least it goes in a sequential order for the reader.
5, cross-reference if you can. While you will want to include the essence of the risk in the body of the risk factor disclosure, you can often pull in additional detail and background by cross-referencing to other parts of the document. For example, when discussing litigation-related risk, it may be useful to cross-reference to the legal proceedings section and/or your contingencies note to the financial statements. Or when describing risks that have actually occurred, have taken place, cross-referencing to a discussion of the event in MD&A may be useful. But it is important to keep in mind that you do still need to actually capture the essence of the risk in the risk factor, and you cannot just rely on the cross-reference.
Number 6, look at peers and other companies for disclosure ideas. Unless you have a peer that has a different fiscal year end than you do, or files their 10K significantly earlier than you, or updates all of their risk factors on a quarterly basis in their 10Qs, this may lead you on a 1-year lag. That's all you're doing. But it's a good sanity check. And in particular, think about running black lines so you can see how companies are changing their risk factors year after year to give you some disclosure ideas.
7, look at recent CorpFin comment letters for ideas. As in so many other disclosure areas, it's useful to see what the SEC is focused on and commenting on in this space. So it could be specificity of the risk factor discussion. Has a hypothetical risk actually taken place? Is your header specific enough? Does it capture the risk? You can learn a lot by looking at what the staff is commenting on.
Hey, listen to your senior managers and others that are high up and see what risks they're describing. So you want to listen to any investor day presentations. If they're on your IR webpage, you can do that easily. Any other discussions of senior managers, perhaps at the board meetings. If you're not in those meetings, you want to check in with the folks that sit in those meetings to see what they've heard, and you want to train them to be your eyes and ears. So once a quarter, you might want to take someone from corporate communications, IR department, whoever's in those meetings, treat them to lunch and have them tell you what risks they're hearing.
9, involve the audit committee and risk or operations committee, if you have one, in the process. The full board will receive drafts of the Ks and will or should receive drafts of the Qs and earnings releases, and will have an opportunity to comment on the disclosures contained in those documents. And some companies will review their draft filings with their audit committee, either in connection with the quarterly audit committee meetings, quarterly disclosure team meetings, or otherwise, to walk them through what is new and has changed over the last quarter, including potentially discussion of changes in the risk factors.
And finally, 10, do everything you can do to get your business people to feed you information about the company's risks. This is really a summary of 8 and 9, but it really is so paramount. You do not want your risk factor section divorced from the reality within the company. Get time with your risks teams, talk with your business leads, finance colleagues, corporate planning colleagues. What's keeping them up at night? And make sure you're capturing that in the risk factor.
And now we'll move on to the don'ts, and Lou's going to kick us off.
1, don't rein in your captions to look like every other caption you've ever written. For this purpose, they very well might be a sentence or two. It's a summary, is the bottom line. So this is the flip side of the first do. You do need to be conveying the essence of the risk to the reader. And again, item 105 is looking for a subcaption that adequately describes the risk.
2, don't not include a risk just because that has a low probability. Inevitably, this is going to be the one thing that occurs, and you'll be grateful that you've included.
3, don't rely on your business people to tell you what the company risks are. Affirmatively reach out to folks across the enterprise and ask probing questions. You are going to need lots of coordination and consultation between and among the disclosure committee, drafting teams, business folks, and executive team, with plenty of brainstorming. Don't wait for folks to come to you. Be affirmative in reaching out.
4, refrain from saying why it's not a risk. This is risk factor drafting 101. You will be sure to get an SEC comment if you try to provide some mitigating factors as to why it's not a risk. If you do have pressure from your business or your certifiers to say, this really seems pretty ugly, is there a way to bring it down a bit? Consider maybe using a cross-reference in your risk factor section to your risk management section, and maybe that could be a way to address the ways that the company is addressing those.
5, don't generalize the risk if it's happening already. So this is the no hypothetical risks warning. This is your big takeaway. You do not want your risk factors to sound hypothetical when in fact something is or has been happening. And again, the best example here is with cyber breaches where they have occurred or attempts have been made. Even if not material, you don't want to be saying that you may be subject to attempts. Probably everyone at this point is subject to attempts. So you can give a little bit of mitigating to say whether or not it's materially impacted you, but you absolutely don't want to say that something may be happening and it actually is or has been.
Number 6, do not keep the order of your risk factors the same in every disclosure. You need to reorder as risks rise and fall. The SEC decided not to mandate your ordering of risk factors in the most recent updates to the risk factor rules. That doesn't mean you shouldn't be going through, putting them into magnitude order and trying to highlight the most substantial risks at the very front.
7, don't be scared to include a macro risk. So on the one hand, you don't want to just simply cite a macro trend or event without tailoring it to the company. You need to show investors why it's particular and specific to your company, how that could be a risk for the company and for them in terms of their investment. But you are going to find instances. Again, the pandemic is a good example. We also saw it with the financial crisis where there are significant macro events that do need to be reflected in the risk factors. So the key here is to just do it in a way that's specific to your company.
Number 8, don't be scared to include general economic conditions risks. Just tailor it. Every company has exposure to the economy. Every company has competition, regulations that they have to contend with. The key with risk factor drafting is to make it tailored and provide examples as to where you and your company are particularly exposed. For general economic conditions, are there particular areas within the economy that you're particularly exposed to? Are there factors that you do look to, like unemployment rates, amounts of discretionary income, or trade issues that you are going to be particularly exposed to? And make sure that those are noted.
9, don't worry about how many risk factors you have. The goal is to capture the material risks and explain them in a way that conveys the risk to the reader. So you're looking for quality, specificity, not quantity. So you should not spend your time worrying about whether someone else has 45 and you have 30. You should be thinking about whether or not you have conveyed the risks for your particular company. Of course, with the SEC changes to SK item 105, you do now have to worry about the length, but that's going in the other direction. So again, don't worry about whether you have enough in terms of quantity numbers. Worry about whether or not they capture your risk.
And number 10, never kill a risk factor. So I say this with tongue in cheek because now we're with the new SEC rules. We're going to be considering maybe we should be killing some risk factors. But I've talked to a number of in-house folks that have been at their company for decades. And I asked them, have you ever killed a risk factor? And they thought about it and they said they didn't think so. In some cases, there was maybe a slow death where they would combine 2 risk factors into one. So they would take out half a risk factor and tuck it into a prior one. But this is really going to be a hard exercise for a lot of people, particularly because we're disclosure lawyers. We think of these documents as compliance documents because they're protecting the company from liability. And so the last thing you want to do is take out a risk factor and actually have that event happen to your company where the risk factor would have protected you, and now you don't have that protection anymore. So good luck to everyone in their exercise. I am glad I am not in-house for that process. And thank you very much, David and Lily. This has been fun.
Thank you,
Bob.